Deputies have reviewed the draft law on the ratification of the agreement between Uzbekistan and Kyrgyzstan on the transfer of persons deprived of liberty to continue serving the sentence. The main objective of this agreement is to ensure that prisoners serve their sentences in the country of citizenship, allowing them to be closer to their families.
This agreement was signed in July last year. It outlines the conditions, procedures, and grounds for transferring prisoners to their home country for sentence execution. Additionally, the document addresses important matters such as the costs associated with prisoner transfer, dispute resolution, official language of bilateral communication, amendments to the agreement, and its enforcement. According to the agreement, the central authorities responsible for its implementation are the general prosecutors' offices of Uzbekistan and Kyrgyzstan. This raises the question, if a convicted person is transferred to their home country, can the assigned sentence be modified?
It is important to consider one key aspect. The duration of imprisonment sentences may vary between the two countries. If the sentence length in the sentencing country matches the period specified in the receiving country's legislation, the inmate will continue serving the remaining part of the sentence after being transferred. However, if the maximum penalty for the same offense differs between the two countries, the receiving country will enforce its own maximum sentence. For example, if a citizen of the Kyrgyz Republic is sentenced to 12 years of imprisonment in Uzbekistan for theft, but the maximum penalty for the same crime in Kyrgyzstan is 10 years, then upon transfer the individual will serve a 10-year sentence in Kyrgyzstan. This means that the punishment will be adjusted based on the maximum term allowed in the receiving country.
Can the verdict issued by sentencing court be changed? Is it possible to apply measures such as amnesty or pardon?
As a general rule, the decision of the sentencing court remains unchanged unless there are exceptional circumstances. The receiving country has no right to modify the sentence. However, changes can be made based on an amnesty act, a pardon, or other specific legal grounds, provided that the sentencing country is duly informed of such modifications.
This agreement aims to safeguard the rights of prisoners, improve their social rehabilitation, and help maintain their ties with their families. During parliamentary session, Deputies approved the draft law in its third reading, and it has now been sent to the Senate. During a plenary session of the Legislative Chamber, a draft concept of ensuring citizens' freedom of conscience and the state policy in religious affairs was discussed. The document proposes measures to guarantee the right to freedom of conscience, implement constitutional provisions affirming Uzbekistan as a secular state, and define the goals, principles, and key directions of state policy in the religious sphere, along with mechanisms for their implementation. The draft concept consists of 7 chapters and 41 articles, and it's intended to be approved by law.
The concept defines the goal of state policy in the religious sector and outlines 10 tasks that serve this purpose. Specifically, the goal of Uzbekistan's state policy is to create equal conditions for citizens to exercise their right to freedom of conscience, promote mutual understanding and respect among religious organizations of different faiths, strengthen interfaith harmony, and ensure religious tolerance and secularism in society.
The plenary session also provided insight into the main tasks of the state policy in the religious sphere, as outlined in the document, to ensure effective parliamentary oversight of the implementation of the concept's key provisions. A parliamentary commission will be established by a resolution of the Oli Majlis chambers. The draft concept and the related law proposals were adopted in the first reading by deputies. The document will be published on the official website of the Legislative Chamber for public discussion.